don't know how powerful your voice is. They don't want to hear another legislator. They don't want to hear somebody else that's advocating. Sometimes they just want to hear that personal story.
The only way to stop asbestos-related cancers is to ban it.
About 40,000 Americans die every year of asbestos-caused diseases.
Erik Olson, who is not only a wonderful human, but he's a brilliant environmental lawyer. He used to do policy work for Senator Boxer. He's now, is it Senior Counsel for Health? You should, yes, but he's brilliant at NRDC, and he's taking his weekend to come here and talk to us. Erik?
Well, thanks very much. It's an honor to be here and to have worked with Linda for 20-something years. I'm going to talk about some of the history of legislation that's passed and not passed, and why it's so challenging to actually address asbestos in so many different products. So my conclusion, I'm not going to hide the ball, is that we still need an asbestos ban. There are about, as you've heard, 40,000 Americans that die every year from preventable asbestos diseases, and about 70 other countries have asbestos bans. The US still doesn't have one. We did have, it wasn't a complete ban, but EPA did issue a ban in 1989 under the Toxic Substances Control Act. Industry sued in a court of appeals that they expected would go with them, and got the asbestos ban overturned in 1991. And the impact of that was not just on asbestos, but on pretty much everything under that law. It completely upended how that law was implemented and basically gutted the law until it was amended. And I know that Bob Sussman is going to talk more about that 2016 statute. The court's decision basically shut down EPA. So there were a lot of proposals, but I'm not going to go through all of them, but Patty Murray, senator from Washington, Henry Waxman, one of my heroes, Steve Cohen, all had the Ban Asbestos in America Act. It was proposed multiple times from 2002 through 2007. The Bruce Vento Ban Asbestos Act also was proposed by Gene Green and Betty McCollum. None of those actually moved. Then in 2017, Linda and I worked on this. We got a Ban Asbestos in America Act passed through our committee, the Senate Environment and Public Works Committee. It then passed the full Senate, but there was a tweak made in it by some Republicans that successfully really weakened it substantially. It went over to the House, and it was never passed through the House. So unfortunately, that's the last time we really saw significant movement on an asbestos ban in the United States, 17 years ago. Obviously, I'm not going to go through the details of what the RBAN Act, the Alan Reinstein Ban Asbestos Now Act, says. It's been reintroduced multiple times since 2016, every Congress for the last 4 Congresses. It was actually approved in committee, in the House Energy and Commerce Committee, by an overwhelming vote of 47-1 back in 2019, but it never got a floor vote. And again, it's been reintroduced. It was reintroduced last year by Senator Merkley and Representative Bonamici, and we'll see. I don't think there's time to enact it this year, so we'll be back at the up to bat again next year. The Asbestos Hazard Emergency Response Act was a significant law. I think we heard a little bit about that this morning. What has passed? That was the most significant first one that passed in 1986. You heard a little bit about it. I'm not going to go into the details, but it does require local school agencies to address asbestos and prepare management plans, and also a model, EPA issued a model plan, which wasn't great, but the major issues have been enforcement, among other things. The Asbestos Information Act passed in '88. It provided some transparency, but didn't fully require full disclosure of imports and manufacturing. Then there was ASHARA back in 1990 that extended funding for the school asbestos abatement program. And it also increased the number of training hours that were required for asbestos model accreditation plans. And also EPA expanded the accreditation requirements to cover asbestos abatement projects in all public and commercial buildings and schools. In theory, again, there have been real enforcement issues with that. The Clean Air Act, this is an important one, and talk about not being enforced. So there's a national emission standard for hazardous air pollutants for asbestos. This was updated in 1990, and theoretically, there are work practices for asbestos control during demolition. I will tell you, half a block from my house, there is a large commercial building that's being demolished, and they're just like barely spraying a little bit of water on it, and you can just see the dust wafting up. I'm sure that they have not complied with a lot of these requirements. This is typical. Asbestos-containing waste, in theory, must be sealed and disposed of in a qualified landfill. The building owner and operator is supposed to notify the state before demolition or renovations if there's a certain amount of asbestos in the building. And some manufacturing and fabrication is not supposed to emit visible emissions to the outside air, and they're supposed to follow certain air cleaning procedures and requirements for the waste. Safe Drinking Water Act, which is something I've spent a lot of time on, EPA did adopt a very weak asbestos and tap water standard, 7 million fibers per liter that are greater than 10 microns in length. One of the fundamental problems here is that a lot of drinking water pipes are made out of asbestos cement pipes, and that stuff can break off and get into your drinking water. And the monitoring for it and the regulations for it are pretty weak. So in a lot of communities, there may be significant exposure to asbestos through drinking water, and it's not something that I know of anybody that's really looking at. CERCLA, the Superfund law. Asbestos was listed as a hazardous substance, and it can be addressed under removal or remediation under the Superfund law. EPA did update its framework for evaluating whether to clean up under Superfund law. Some sites have been cleaned up or are planned for cleanup under Superfund, but these tend to be the industrial sites that have really severe asbestos contamination, and it hasn't been, frankly, a huge success so far. So Toxic Substances Control Act, as I mentioned, the 1989 ban on asbestos was overturned, but the agency did issue a worker protection rule. Basically, it just expanded the OSHA rules, which I think you've heard are pretty weak and not very well enforced, just expanded those to state and local government employees. The Lautenberg Act, which I know Bob Sussman's going to go into much more detail on, it strengthened TSCA somewhat. The problem obviously has been that there are a lot of shortcomings in the implementation, and there's some limitations in the law itself. The agency has issued a couple of rules. One was on discontinued uses. I'm assuming Bob is going to talk about that perhaps a little bit. And then there's a reporting and record keeping rule which is very limited, but requires some reporting by recent manufacturers and importers and processors of asbestos. This one I know Bob's talking about, so I'm not going to spend a lot of time on, but there was a Part 1 asbestos rule that was very limited just to one form of asbestos, chrysotile, and also applies to just import of asbestos for chlor-alkali facilities, which is one of the major ongoing uses of asbestos in industry right now. It's phasing out those facilities in the coming years. And then the Part 2 asbestos risk evaluation, which Bob is going to talk about, reviews some of the legacy uses, and obviously Bob will discuss some of the litigation that was necessary to bring some of these actions. Other federal agencies also have some degree of regulatory requirements. OSHA in particular has these three standards that I just am going to highlight. One is the Asbestos General Standard for permissible exposure limits and some engineering controls. Asbestos Construction Standard, again, this, I think if you go to construction sites where there is demolition going on, how many of the workers are complying with the asbestos construction and demolition standards? I think it's very unusual that there is compliance. Same thing with shipbuilding, including demolition, salvage, and repair of ships. And then obviously some of the shortcomings in the rules are significant, and then there's real compliance issues. Other federal agency rules include Consumer Product Safety Commission rules. They're very limited for emberizing materials, those things in a fake fireplace, patching compounds, and some garments with asbestos. I love these slippers made out of asbestos. Those, in theory, would not be allowed anymore under CPSC rules. Mine Safety and Health Administration, in theory, some limitations for surface and underground mines with asbestos, although, as we all know, I think most of the asbestos mining is overseas. Basic conclusion is that there are very limited and often weak EPA and other agency rules regarding asbestos. There are huge gaps in protections, and really the only solution here is a nationwide ban enacted along the lines of the RBAN Act. Thank you.
You have a few
Yep,
minutes left.
I do.
Could you add just a bit about the Chevron deference opinion, because that was an NRDC case?
It was.
Okay.
Yeah, so Linda asked me about the Chevron deference opinion. There's a case called Loper-Bright that was recently decided by the U.S. Supreme Court. It's one of these decisions that the 3 new justices were basically the driving force, in particular, Justice Gorsuch, whose mother was the EPA administrator back in the day when I worked for EPA, believe it or not, under President Reagan. And that decision, basically, there has been a longstanding multi-decade decision called Chevron versus NRDC, my organization, that basically said that the courts will give deference to the expert agency's interpretation of a statute. That decision has driven a lot of district court and Court of Appeals and subsequent Supreme Court decisions for the last 40 plus years that, like EPA, gets deference when they interpret their statute. This decision that was recently handed down, the Loper-Bright decision and another decision, basically threw that out the window, reversed the decision, the Chevron decision, and basically says that the courts can make their own mind up without having to give any deference to EPA or other federal agencies that are experts in the field. And the fundamental issue now is that whenever EPA issues a rule, they are going to be subject basically to de novo review of their interpretation of the law. And that will make it easier for industry potentially to sue and overturn EPA rules on asbestos and anything else. The flip side is that a group like NRDC, if a bad administration starts making bad decisions, NRDC would also, and other plaintiffs, other petitioners, other public interest groups will be able to sue over those and get them overturned. So that may be sort of an unforeseen consequence for industry, that we and some of our colleagues may be able to get bad decisions by agencies overturned. So we'll see. I mean, I think the industry has been driving for this for so long because they have, bottomless pits of resources to try to overturn EPA and OSHA and other rules, and we fully expect them to take maximum advantage of this decision and to try to overturn EPA and other agency rules. So we'll see how that works out. We haven't seen a lot of new cases yet because it's a fairly new decision, but stay tuned.
So you guys can follow NRDC and thank NRDC for their excellent practices, because they do a lot. Thank you, Eric.